What are the conditions? There must be a valid marriage between the spouses. If the marriage between the husband and wife is valid, then only the husband is entitled to take a share from his wife's property. That is, the relation between husband and wife must be subsisting at the time of the death of the female. If that relation was not there, then the husband is not a husband. Then husband is not entitled to take a share from his wife's property. Example, you take a divorce. Suppose that there is a divorce has been declared by the court between the spouses. Once the divorce has been declared, he is no more husband. Then he is not entitled to take a share from the female property. Similarly, the marriage is declared as a null and void by the court, by the competent court. Then also he is not a husband. When he is not a husband, how can he take a share from the female's property? So divorcee, or where the marriage is declared null and void, they are not entitled to take a share. Similarly, suppose if the husband obtained a decree of judicial separation, divorce has not been granted, still they are under the judicial separation. At that time the wife died, still the husband is entitled to take a share from his wife's property, because the relation has not come to an end. Till the court declares a divorce between the parties, still they will continue as a husband and wife, so the husband is entitled to take a share from his wife. Not only that, just the husband is living separately. The husband is living separately, away from the wife. Even if the wife dies, the husband will get the share, because the relation between them is a husband and wife. The relation is subsisting, existing at the time of the death of the female Hindu. So the husband is entitled to take a share from his wife's property. These are the first entry which we have completed. Now let us go to the second entry. The second entry includes the heirs of the husband. If all the children are absent and there are no grandchildren, husband also died, then the property will pass on to the heirs of the husband. So who are the heirs? How the property, before the husband died, prior to the death of the wife, how the property will come to the husband? It is presumed. It is presumed, even though the husband dies prior to the death of the female Hindu, prior to the death of the wife, it is presumed that the husband died immediately next to the death of the female Hindu. Again I am repeating, the husband died before the death of the wife, but still it presumed that the husband died next after the death of the wife. So the property will be transferred from female to the husband and from husband to the heirs. This is how the presumption will work out, and the property will pass from a woman, that is the female Hindu, to her husband, and husband to the heirs. Who are the heirs? The heirs who are entitled to succeed to the property under this act. According to this act, who are the heirs? So the property, when you come to the female, there are two types of property. One is ancestral property and the other is a separate property. But here the property derived or inherited from his wife is a separate property. So when the property is a separate property, what are the rules applicable? Section 8 to 13. So the schedule of section 88 says, who are the heirs? Class 1, class 2, agnates and cognates. So section 8 to 13 applicable under this category. Class 1 heirs, class 2 heirs, agnates and same principles, the same rules all apply here also. But the wife has two husbands. The two husbands died. First, you take the previous illustration only. The husband, she married a H1, first husband died, and again she married H2, the second husband. He also died. H1 also had the heirs, and H2 also had the heirs. Who will take the property? Both the heirs of husband, heirs of the first husband, heirs of the second husband, all will stand in the equal degree and they are entitled to take the property. There is no preferential right. There is no preferential right. But here there is one problem. One problem. The property is passing from wife to the husband, and according to section 8 to 13 the property will be distributed, and first priority comes to the class 1 heirs. Suppose if the husband had children with the second wife, the property is going to the children. You see this illustration. In this illustration, the deceased is a female intestate, she died, and her husband is the H. Both have no children. Husband also died. The property will pass to the heirs of the husband. So who are the heirs? He had a second wife, that is X, and with the X he had 2 children, that is S and D. So the female intestate property is transferring to the H husband, and from husband the property is equally distributing between the children of second wife. How injustice it is. So there is amendment is required under this category. The property of female intestate is going to the children of the second wife. Suppose if the second wife is also alive, the property will be, she is also in the class 1 heir. The property will be divided equally. Each will get 1/3, 1/3, 1/3. Suppose if the second wife dies, the property will be equally divided between daughter and son of the second wife. So here the property is not going to her father or mother. The property is not going to her brothers and sisters, but the property is going to the second wife of the husband and to their children. Next, heirs of the third class entry. Here there are only 2 heirs, that is the father and the mother. Who are the father and mother included? So as usual, natural mother, father, adoptive father, and mother and father are included. But the mother is entitled to take a share from the illegitimate daughter, but father is not entitled. Suppose if the daughter is an illegitimate, that is born before the marriage, mother is entitled to take a share from daughter. What about the step parents? If you come to the step parents, generally the father's widow. The father's widow is included in class 2 and entry 6th. Father's widow is included in entry 6 of class 2 heirs. She is in the class 2 heir. Father's widow. Father's widow is nothing but a stepmother, because natural mother is in the class 1 heir. So here comes step widow of the father, means stepmother. She is included in the class 2 and entry is 6. So the property passes from daughter to the father and father to the stepmother. So stepmother will take a share if all the class 1 heirs and above 5 entries are absent, she will take the property. But stepfather is not included anywhere. So stepfather is not entitled to take a share from daughter's property. When you come to the adoptive father and natural father, once the child has been given to the adoption, the adoptive parents will become the natural parents, so they will take the property and the natural parents will be excluded. But what is required is, when the succession opens, the girl has to pass into the adoptive family. Then the adoptive parents are entitled to take a share from the daughter's property. Whether the father has been divorced or mother has been divorced or father and mother are living separately, these are all irrelevant. Father is a father, mother is the mother. Even they are living separate, it's all irrelevant, and both are entitled to take a share from the daughter's property. That is the female intestate of the property. Now let us come to the heirs of the fourth class or the fourth entry. So here included the heirs of the fourth class are the heirs of the father. Heirs of the father. So who are the heirs? Again, the property that is the father is inheriting from his daughter is considered as a separate property. It is not ancestral property, it is a separate property. So section 8 to 13 applies. According to section 13, who are the heirs? Again, class 1, class 2, agnates and cognates, and the same rules will apply here also. And the last is entry is fifth entry, the heirs of the mother. Heirs of the mother. What are the who are the heirs? Section 15 and 16 applies here. Again, section 15 and 16. According to section 15, the list, her children, husband or heirs of the husband, father, her father and mother, and so on. So here natural mother's heirs are included, or adoptive mother heirs are included. Suppose if the mother is an illegitimate, her heirs are entitled. So all the mothers, whoever it may be, their heirs are entitled to take a share from the property of the daughter. So all these entries will get only if the mother's heirs are want to get the property. All the above 4 entries must be absent. All the 4 entries must be absent. Then only they are entitled to take the property. So this is how the persons are included in the first entry list, and these are the persons, these are the qualification. They are entitled to take a share from the daughter, wife or mother, whoever it may be, basing upon the relation. Now what is the property? Property is not specifically defined anywhere under the Hindu Succession Act. But however, the property includes movable property or immovable property, or both movable and immovable. But what is required is the property must be either inherited or acquired by her own in any manner. That is, she must have an absolute control over the property during her lifetime. This is the only condition is required to apply section 15 and 16. The property is an absolute property and it is under her control during her lifetime. Then only this section 15 is applicable. And this section does not make any difference between the property inherited or self-acquired property. If you look into the Hindu male, there are 2 types of property. One is the ancestral property and the other is self-acquired property. Ancestral property and self-acquired. There are different rules. For ancestral property, section 6 applies, and separate property or self-acquired property, section 8 to 13 applies. But there is no such differentiation in case of the female property. Whatever may be the nature of the property, whether it is a self-acquired or inherited from any source, same rules are applicable. That is section 15 and 16. Only is the property is absolutely had a control.